That's it. No hurry. The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone here today to this hearing on the right to repair. I'll now recognize myself for an opening statement. Thank you all for being here today and for advancing a better understanding of the critical issue for consumers, for business, and for the overall economy. And as you might hear me say repeatedly today, and for the environment. This hearing marks a unique opportunity for members of the subcommittee to come together to learn the positions of all sides of the right to repair ecosystem that this subcommittee has jurisdiction over. It is clear that this subcommittee lacks jurisdiction in antitrust, which will be taken up by another committee. But it is that combination of the power of those who object to the right to repair and those who, for various reasons, have an interest in seeing reliable, low-cost, predictable parts to be available from multiple sources whenever possible. As I will say throughout the day, and we will see throughout the day, this topic sparks passionate debate among the various stakeholders, and that's an understatement, including manufacturers, independent repair shop, environmentalists, and consumers. As we explore the importance and need for right to repair legislation, it is critical that we consider all perspectives and to ensure a balanced and effective solution. And when I say that there's an importance for federal legislation, I say so in no small part because states are finding solutions on their own, and a patchwork of 40, 50 separate solutions leads to confusion and, in fact, to a lack of exactly what we're hoping to have, which is protection for the manufacturers and their copyrights and patents, and an opportunity and an effective way to have safe replacement parts available to all. Let there be no doubt, the right to repair the product that you have purchased is a fundamental principle that individuals and businesses should not, under any circumstances, have any doubt as to where the bright lines are in their rights. From smartphones to home appliances to the firmware on cars, there is today doubt. The doubt is state by state, product by product. Many companies have a long tradition of aftermarket products. I'll take, for example, if you have a CJ Jeep. There are so many places you can buy so many parts, and in fact, the mystique of that World War II derivative product and its success and longevity of more than half a century relies on the fact that you can not only buy a new vehicle today, but you can buy a 40 or 50-year-old vehicle, and there are a plethora of parts available. That same company markets other products that today they would have you believe you should not have the same choice you have in that iconic vehicle. And hopefully we'll bring up some of those ambiguities between the aftermarket and the manufacturers today. The right to repair is about empowering consumers, promoting competition, and extending innovation. It can be a key driver of growth and prosperity. Right to repair fosters consumer choice and freedom to enable consumers to protect their investment and extend the lifespan of their product and devices. It is a fundamental consumer principle. The hearing is also an opportunity to hear and learn from those with questions and concerns, and we need to hear from them. The right to repair does have to be balanced with a deep and legitimate concern for safety. I think there can be no better example than that of the factory-equipped airbags. These are classic examples of products which are becoming higher and higher tech, which in fact often are of great cost. But quite frankly, as someone who once was in the auto security market, we also know that manufacturers live in terror that an automobile that has had its airbags deployed will have a replacement or a bypass put onto that vehicle and ultimately lead to the death or injury of a passenger. We must legitimately balance safety concerns. We must give an opportunity for those safety concerns to be heard. But let's have no doubt, flared fenders are in fact here to stay. Well, I am proud to sponsor the SMART Act, a bill that will expand consumer choice for automobile collision repair parts, decrease costs for both drivers and insurers, and enhance competition in the automotive repair parts market. It is not a be-all solution, and it is only a small piece of the solution that we have here today. By enacting comprehensive and well-thought right to repair, we can create fair competition, sustainable repair ecosystems, and benefit all shareholders. Before I recognize the ranking member, I want to put forward two principles today. One, well-established, the concept that there is a standard essential patent, well understood, and by this committee within our jurisdiction. There is no similar history of a standard essential copyright. Today, in discussing the right to repair, hopefully we will look at both of those as principles that should, in fact, create a balance between the intellectual property holder, the investment they've made, the legitimate right to return on their investment that they have, versus the fact that there often is no other choice but to step directly on what one would claim to be a patent or a copyright if there is going to be any replacement part or other repair part created or installed. And so with that, it's my pleasure to recognize the ranking member, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman, and I'd like to begin by thanking you for bringing together experts from both sides of this important conversation. Thank you also to our witnesses for being willing to lend us your time and your considerable knowledge today. I feel privileged to serve as ranking member of a subcommittee that supports creators and keeps our American innovation system strong. Together, we on this subcommittee tackle complicated intellectual property policy issues that have no clear solutions in an often bipartisan manner, and I'm looking forward to doing so again today. Right to repair is one such thorny policy issue, and the debate over an appropriate solution encompasses issues and individuals far outside the scope of this subcommittee. Environmentalists, economists, and antitrust experts, to name a few, have all weighed in on the problem and proposed solutions. But we're here today because the question of repairability incorporates intellectual property concerns as well, including but not limited to the design patent and copyright spaces. Repair shops, once a common feature of every small town main street, have become largely a distant memory. We have all had the experience of having a home appliance break and discovering that it would cost more to fix than to simply replace. So we toss the microwave oven or vacuum cleaner or desk lamp into the trash and head to our local store for a new one. Fault for the demise of repair has been leveled at changes in production, poorly made devices, and an absence of economic incentives. These charges, are not for us to determine today, but I would note that the incorporation of software into everyday items, from coffee makers to cars, has made an already challenging discussion even more complicated. Because businesses that seek to repair these broken items argue that some of the laws protecting patent and copyright holders preempt them from doing so, and they say that these intellectual property provisions are being deployed outside their contemplated purpose when the laws were first enacted. Others assert that this argument is what we've heard time and time again from those who find innovation protections inconvenient to their industry. They remind us that intellectual property laws exist to encourage investment in new ideas. I'm here today to listen and learn, and I'm looking forward to hearing from our witnesses how any legislative solutions that come before this committee can continue to protect our inventors and creators while increasing consumer choice. Much of the conversation about copyright interference with the repair market is focused on Section 1201 of the Digital Millennial Copyright Act, or DMCA, which prevents digital piracy of online copyrighted works. When the DMCA was passed in 1998, those of us who had access to the internet at home used a dial-up connection. We went out and bought a CD if we wanted to listen to a new album, and phone calls were likely made on a device attached to the wall by a cord. Conversely, today, even the most mundane devices are connected to the Internet of Things. The world has changed, and with it, the number of items that fall under the auspices of Section 1201. In a 2017 report, the Copyright Office itself acknowledged that Section 1201A, its protections for access controls, have the potential to implicate activities far outside the traditional scope of copyright law. Yet, Section 1201 contains a provision allowing for triennial exemptions that is designed to prevent non-copyright infringers from running afoul of this statute. I'm looking forward to hearing from the assembled witnesses about whether the DMCA and Section 1201 in particular is working as intended. But the debate over right to repair is not limited to copyright issues. Design patents, particularly design patents for component parts of a vehicle, are often the target of considerable criticism by car repair experts. As we explore solutions to this and other areas of intellectual property concern voiced by the repair community, it is crucial that we keep in mind the importance of patent protections to innovation and seek to ensure we leave behind a healthy system for generations to come. We should all agree that there is a problem with repair today, and when the only option is to just buy a new one, we all lose. Finding a solution, however, is a weightier task, but it is one I look forward to seeking together. Thank you again, Chairman Issa, for holding this important hearing, and I look forward to hearing from our esteemed witnesses.
Thank the gentleman. We now recognize the ranking member of the full committee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, debate over whether consumers in repair shops have a right to repair devices and what the limitations to that right might be has grown louder over the past 10 years as technological innovations have added complexity to our products. Many of the laws protecting manufacturers and preventing individuals from bypassing access controls or making a replacement part are the same statutes that protect inventors and creators. The intersection of the right to repair movement with intellectual property rights is naturally a delicate issue. I appreciate the opportunity to work towards a bipartisan solution that respects both consumers and creators. I'm grateful to Mr. Issa and Mr. Johnson for bringing in witnesses with wide-ranging perspectives on this matter, and I am looking forward to hearing what role they believe Congress should play in addressing the issue of right to repair as it relates to intellectual property laws. The battle between repair businesses and manufacturers is nowhere as public or as acrimonious as it is between car companies, known in this context as original equipment manufacturers, or OEMs, and repair shops. What was once exclusively a fight over design patent protections for vehicle component parts has expanded to encompass a broader swath of disagreements that expand far outside the purview of this subcommittee. Vehicles are no longer simply gas-powered engines. cars are computers on wheels. Who can repair those computers and how is already being considered at the state level. Citizens in Massachusetts, for example, passed the ballot initiative requiring any car with a telematics system to incorporate an open access data system allowing any repair shop to access the data. In response, some car companies simply cut off access to remote start and other software-powered accessories, depriving consumers of these features. Determining who should be able to access and repair vehicle software is anything but straightforward, and we must consider the serious personal privacy, cybersecurity, and intellectual property concerns inherent in automotive right to repair. But as we consider these complex questions, we should remember that most consumers just want somebody to fix their cars when they break. For years, for generations, Americans have taken their cars to a local garage when something goes wrong, a right that was reaffirmed by a 2014 Memorandum of Understanding between the repair shops and the OEMs. It is highly concerning to me that in spite of the 2014 MOU, rather than seeking a fix to the safety and cyber concerns inherent in technological innovation, OEMs have sought to steer customers back toward dealerships and away from the car mechanic that they trust. I was glad to see the recent agreement between OEMs and independent repair facilities on this issue, and I am looking forward to hearing from our witnesses about what we can do moving forward to address this issue to the extent that it overlaps with intellectual property concerns. Software innovation is not limited to trucks and cars and other motor-operated forms of transportation. The onset of the Internet of Things has prompted new debates over intellectual property protections and whether access to that software should be granted to make repairs. Many of us here today have had the experience of cracking our smartphone screen and spending the day trying to figure out how quickly we can get it back up and running. Right to repair advocates argue that a customer should be able to take the phone to any repair shop, not just to the manufacturer, and they argue that such consumer choice would drastically lower the right to the cost of repair. Moreover, they say, copyright protections designed to protect creators are being used to prevent such easy fixes, not just for phones, but also for printer cartridges, kitchen appliances, and other typically non-internet connected devices. But we must proceed with great caution when considering any changes to the copyright laws to ensure that the fundamental rights of creators are protected. American laws protect software developers by granting them copyright ownership over the lines of code they write and the software they create. Section 1201 of the Digital Millennium Copyright Act prohibits circumventing any measures designed to prevent unauthorized access to this copyrighted material. But Section 1201 also sets forth a process every 3 years to grant certain exemptions to these access controls. And I look forward to hearing from our witnesses on whether the consumer protections we need can be found within the existing 1201 process or whether further reforms are needed. The solution to protecting consumers in the market for repairs cannot be that copyright protections and design patents do not matter in the United States, or that they only matter when they are convenient. Consumer protection and consumer choice, however, are also important, and it is incumbent upon us in Congress to protect innovation while ensuring that everyday Americans aren't left holding the bill. Congress does its best work when we work together across the aisle, and I am optimistic that this issue may be one of those rare opportunities in today's political environment where we can reach consensus. I look forward to hearing what our witnesses from both sides of the debate have to say, and again, I thank the Chairman and Ranking Member for putting this panel together today. I yield back the balance of my time.
I thank the Ranking Member. Without objection, all other opening statements will be included in the record, and it's now my pleasure to introduce our panel of witnesses. Mr. Scott Benavides, or close to it, is the owner of Mr. B's Paint and Body Shop, a family-owned and operated collision repair facility in Albuquerque, New Mexico. He is the chairman of the Automotive Service Association, or ASA, which represents and advocates for automotive repair industry. Mr. Devin Hartzline is an intellectual property innovation legal fellow at the Hudson Institute Forum for Intellectual Property. He previously served as an assistant professor at George Mason University the Scalia Law School, where he taught a course in intellectual property law and copyright, patent, and trademark law. Professor Aaron Berzanowski, or even further from the accurate perhaps, professor is a professor at the Thomas W. Litka Professor of Law at the University of Michigan Law School. His courses focus on intellectual property, trademarks, copyrights, and the law and policy of repair. He is an author of 3 books on intellectual property, including the catchy term, The Right to Repair. Mr. Paul Roberts is the founder of Secure Repairs, an organization of information technology and security professionals who support the right to repair. He is also the publisher and editor-in-chief of the Security Ledger, an independent security news website. Mr. Carl Wiens is the co-founder and CEO of iFixit, a website and retailer that provides repair guides for consumer products and sells replacement parts and specialized tools, meaning those tools that let you reset that pesky light on your dash. iFixit also advocates for the right to repair and other legislation. We welcome our witnesses here today. As is the rule of this committee, I would ask you all to please rise to take the oath. And raise your right hand as tradition. Do you swear or affirm under penalty of perjury that the testimony each of you is about to give will be the truth and correct to the best of your knowledge, information, and belief, so help you God? Thank you. Please be seated. Let the record reflect that all witnesses answered in the affirmative. As you may have seen on C-SPAN in the past, we will tell you that you have 5 minutes, and yes, we will gavel. However, your entire opening statements, along with additional information you want to have placed in the record now or for the 5 days after this hearing, will be put in. So let there be no doubt, all that you want to say will be said in writing, if not said orally here today. And with that, please introduce yourself so that I can get your pronunciation exactly right, Mr. Benavides.
Mr. Benavides.
Vides.
Scott Benavides.
Okay, thank you, Scott. You're recognized.
Thank you. Good morning, Chairman Issa, Ranking Member Johnson, and members of the subcommittee. Thank you for providing me the opportunity to testify before you today. My name is Scott Benavides. I'm the chairman of the Automotive Service Association's Board of Directors. I am also a second-generation shop owner from Albuquerque, New Mexico, Mr. B's Paint and Body Shop. Independent automotive repair shops are responsible for the majority of all post-warranty repair services in the United States. ASA has been steadfast advocate for right to repair principles, the right of car owners and independent repair shops to access vehicle service information needed to diagnose and repair vehicles for decades. We take this unequivocal stance because our members are on the front lines of the vehicle data access issue, and we have been very clear. We want to have access to the data necessary to repair our customers' vehicles. The 1990 Clean Air Act amendments assured independent shops the same emission service information that was provided by automobile manufacturers to franchise car dealers. In 2002, ASA signed an agreement with automakers stipulating that independent automotive repair shops would have access to the same emissions and non-emission service information provided to the manufacturer's franchise dealerships. Since 2002, the vehicles Americans rely on have become increasingly sophisticated, and we know that rate of innovation will only accelerate. The way vehicle issues are diagnosed and repaired evolves in tandem with technological advancement. The modern vehicle is essentially a computer on wheels. And just like a typical computer, an enormous amount of information is passed wirelessly to and from the vehicle. In many instances, our shops wouldn't be able to diagnose and fix problems their customers ask them to solve if they didn't have access to telematics. Car owners deserve a competitive market from which they can select a repairer who will fix their vehicle at the best price. Although today automotive repairers have access to vehicle data necessary for repairs, our industry has been concerned about the path forward for obtaining data in the vehicles moving into the marketplace. Newer vehicle technologies with an increasing number of sensors will present a challenge to our shops without access to the repair data. That's why last week, ASA proudly announced that it reached a landmark agreement with the automakers that ensures independent repair shops can diagnose and repair their customers' vehicles without hindrance from telematics nor any other innovation. With regards to the SMART Act, we support a competitive crash part marketplace, but without additional quality standards, we are concerned about the impact on shops and consumers. Although collision shops work closely with insurers as part of a direct repair program, we are mindful that our customers' vehicles are our first priority and that these vehicles must be safe and satisfactory to the customer when they leave our shops. We do have concerns when some insurers insist on repairs that are simply cheaper and quicker without regard to quality and safety. Repairers understand better than anyone the threat of replacement crash parts or lesser quality. We can and should have a competitive marketplace that doesn't compromise quality or safety. Deciding to only cover the cheapest option without understanding implications for quality leaves collision shops and their customers in a tough position. Very few consumers have the knowledge about these types of crash parts used on their vehicles, as numerous crash parts in the marketplace, such as OEM, original equipment manufacturer parts, certified aftermarket parts, reconditioned crash parts, and recycled crash parts. Repairers can make recommendations, but their customers are unlikely to adhere if the insurance won't cover them. One of the top concerns we hear from our members and others at collision industry events is that collision repairs facilities should adhere to OEM repair procedures. This doesn't mean that OEM parts must be used in all cases, but OEM repair procedures should always be followed. Adhering to the manufacturer's guidelines allows independent repair shops to assure car owners their cars were repaired to the highest possible standard and protects them from unjust liability. Assuring more imported and other crash parts in the marketplace with limited quality standards gives insurance companies even more power to mandate that cheaper parts that may or may not meet quality expectations be installed, while leaving car owners and repairers to suffer the consequences. We fear the absence of quality standards in the SMART Act could negatively impact the quality of replacement crash parts. Parts that look the same may differ significantly in terms of quality and safety. Once again, car owners and repairers stand to suffer the most direct injuries and repercussions. Thank you again, Chairman Issa, for convening this important hearing and allowing me to share the perspective of ASA and independent repair shops. I look forward to answering your questions today.
Thank you. Mr. Roberts.
Chair Issa, Ranking Member Johnson, and subcommittee members, my name is Paul Roberts, and I'm the founder of Secure Repairs. We're an organization of more than 350 cybersecurity and information technology professionals who support the right to repair. I'm speaking to you today on behalf of our members to make clear that the fair access to repair materials sought by right to repair laws does not increase cyber risk, and in fact, it can contribute to a healthier and more secure ecosystem of smart and connected devices. Proposed right to repair legislation considered by this Congress, such as the Repair Act or last session, the Fair Repair Act, simply asks manufacturers that already provide repair information and tools to their authorized repair providers to also provide them at a fair and reasonable price to the owners of the devices and to third parties that they may wish to hire to do the work. By definition, the information covered by right to repair laws is not sensitive or protected, as evidenced by the fact that the manufacturers already distribute it widely to hundreds, thousands, or even tens of thousands of workers for their authorized repair providers. This could be everyone from mechanics working at auto dealerships to the folks staffing the Geek Squad at Best Buy. Also, we have yet to find any evidence that the types of information covered by right to repair laws, like schematic diagrams, service manuals, diagnostic software, and replacement parts, act as a portal to cyber attacks. The vast majority of attacks on internet-connected devices, from broadband routers to home appliances to automobiles, today exploit weaknesses in the embedded software produced and distributed by the manufacturers, or alternatively, weak device configuration. So they're deployed on the internet in ways that make them vulnerable to attack. These security weaknesses are an epidemic. A recent study of the security of Internet of Things devices by the company Phosphorus Labs, or a cybersecurity company, found that 68% of Internet of Things devices contained high-risk or critical software vulnerabilities. As an example, I'd like to call attention to the work of a group of independent researchers recently, led by Sam Curry, who published a report, and you can Google this, Web Hackers versus the Auto Industry, in January 2023. That group disclosed wide-ranging and exploitable flaws in vehicle telematics systems from 16 different auto manufacturers. At a leading GPS supplier to major automakers, the researchers claimed to obtain full access to a company-wide administration panel that gave them the ability to send arbitrary commands to an estimated 15.5 million vehicles, including vehicles used by first responders, police, fire, and so on. Hacks like this take place without any access to repair materials, nor is there any evidence that providing access to repair software will open the doors to new attacks. As an example, a diagnostic routine that identifies a failed component or reveals the operating temperature of a device doesn't provide access to the kinds of sensitive data that hackers are interested in. We're experiencing today an epidemic of insecure, hackable, internet-connected devices, and in response to that, we really need a reset. For the last 25 years, Section 1201 of the Digital Millennium Copyright Act has given manufacturers an incentive to deploy software locks widely and to limit access to security researchers. That's kind of a model, what we call in cybersecurity, security through obscurity. In other words, by keeping the workings of something secret, you're making it secure. But in fact, that doesn't work because cyber criminals are very resourceful and they're very determined, and they don't really care what the law says. Section 1201 has also enabled what one researcher has described as dark patterns in the design and manufacture of hardware. That includes everything from locking out customers from access to administrative interfaces, administrative features of the products that they own, as well as practices like part pairing, which Kyle will talk to you more about, in which manufacturers couple replaceable components like screens and sensors and cameras to specific device hardware. Such schemes make manufacturers and their authorized repair providers gatekeepers for repairs and effectively bar competition from the owners of the devices as well as independent repair providers. As the Internet of Things ages and manufacturers gradually step away from their responsibility to support and maintain deployed products, for example, by providing software updates and security patches, reforms to Section 1201 and the passage of right to repair laws can nurture a market-based response, a diverse ecosystem of small aftermarket service providers that will step into the shoes of OEMs, supplying needed software updates and security patches, and servicing and repairing deployed devices. Such policy changes will also foster a range of business and employment opportunities up and down the economic ladder. To sum up, federal right to repair legislation like the Repair Act and the Fair Repair Act will greatly improve the quality of life for consumers, families, and communities while promoting small business and reducing e-waste throughout the country. On behalf of our more than 350 members, I urge this committee to support the passage of right to repair legislation and reforms to Section 1201 of the DMCA, and I'm happy to answer any questions that you may have.
Thank you. Mr. Wiens.
Thank you, Chairman, Ranking Member.
Your microphone may need a little more help.
I fixed it. Thank you, Chairman.
So quickly.
I can do this. I did a workshop with the EPA, and I took their microphone apart for them, so I'm accustomed to these things.
But with all due respect, normally Mr. Massey is here to take care of that for all of us.
I appreciate it. Thank you so much for having me. It's an incredible honor. I have been working on this issue really since high school. I was working at a authorized repair shop. I was making $6.50 an hour. The entire time I was in high school, I saved up for a computer for college. I bought this iBook for $1,850, took it to college, and of course, the first thing I did was dropped it on the power plug. And it was just devastating. It was my access to doing my schoolwork. And so my grandfather had given me a soldering iron when I went to school. He thought I was studying computer science and I would need a soldering iron. That's not what we do. We type on keyboards. But I figured I could take it apart and just fix the cracked solder joint. So I started trying to take the computer apart, and I realized very quickly that I was in over my head. There were cables and wires all over the place. I was like, this is going to be an incredible pain. So I did what I think anyone would do, and I Googled for how to open the computer, and I knew what the service manuals looked like. I could not find the service manual anywhere. And so I bumbled my way through the repair. I got the whole computer apart, and then the biggest mistake that I made was I went to sleep and figured I'll put the computer back together in the morning. And without a service manual, I managed to barely do it, but it was really hard. And afterwards, I was asking myself, why was this so difficult? And I did a little more research, and I learned that the service manual had been online, but Apple had sent DMCA takedowns to every single website that hosted the manual. So manufacturers are using legal avenues to stymie repair, and that was really the window of opportunity. Wow, this really is a challenge. So ever since then, I've been fighting to open up access. I took the computer apart again. I took pictures. I wrote my own manual. We published it online, and it's been very popular. Last year, 1 in 10 Americans used iFixit to learn how to fix something, whether it's a cell phone or a car or a skateboard. We help people fix a wide variety of products. And that's really important because we have to have a resilient alternative ecosystem for repair. You think about what is local, what is American Main Street? You have a post office and a repair shop, and unfortunately, we've seen the whittling down of Main Street as the TV repair shops went away when the manufacturers cut off access to schematics, as the camera repair shops went away when Nikon and Canon decided to stop selling them parts. We've seen this systematically across the economy. In the enterprise space, you have Oracle and IBM saying that you can't get security updates to critical cyber infrastructure unless you buy a service contract with them. So they're tying long-term service contracts with the security updates that are necessary to keep this infrastructure secure. Across the industry, we've been working on right to repair legislation in a number of states in the last couple of years. Massachusetts passed auto right to repair. Colorado passed electric wheelchair and tractor right to repair. We passed a broad sweeping consumer electronics right to repair in New York, and then Minnesota took it one step further, adding enterprise electronics and appliances. So you're seeing this spread across the country. California has a bill that is poised to pass very soon. As we've advanced that legislation, we've heard a lot of objections from manufacturers. Apple claims that they've told legislators that if they can fix their iPhones, they'll hurt themselves with the batteries. John Deere doesn't really seem to care about the safety of farmers. They say that's not a concern fixing tractors, but farmers will screw up the emission systems on the vehicles if they mess with them. The car manufacturers don't really seem worried about the emission systems on vehicles. They think independent mechanics can do that just fine. But the mechanics will stalk their victims, will stalk their customers, sorry, if they have access to telematics data. The medical device manufacturers don't really seem to care about the privacy of patients, but they're concerned that the hospitals, if they can repair their own equipment, will harm patients. I take that one personally because during the pandemic, the hospital biomed technicians were instrumental in keeping the fleet of ventilators in this country functional and working. Over the last decade plus, I've been working on Section 1201, trying to get exemptions for the ability to repair products. The challenge that we've had in the Section 1201 process, every triennial I go back and we ask for permission to be able to fix our own things, is that the exemptions we've gotten really only apply to individual consumers. They aren't something that I could use to make a tool to provide to one of you to fix yourself. So in order for someone to take advantage of a 1201 exemption that we have, they have to be a cybersecurity researcher and able to whittle their own tools and use it themselves, and that just doesn't scale. So across the board, across the issues, we're seeing solutions rolling out, but the fix that is incumbent on Congress really at this point, 1201 has to be solved here. It can't be solved anywhere else. Thank you very much.
Thank you, Mr. Hartline.
Chairman Issa, Ranking Member Johnson, and members of the subcommittee, thank you for the invitation to testify at this timely and important hearing. My name is Devlin Hartline, and I'm a legal fellow at the Hudson Institute's Forum for Intellectual Property. I'd like to start with the question posed by the title of this hearing: is there a right to repair? And the answer is clearly no. A right is a legally enforceable claim against another, but the courts have not recognized that manufacturers have the duty to help consumers make repairs. Instead, the courts have said that while we have the ability to repair our things, we also have the duty not to infringe the IP rights in the process. So it is in fact the manufacturers who have the relevant rights, not consumers. Right to repair supporters want lawmakers to force manufacturers to make the tools, parts, and know-how needed to facilitate repairs available to consumers and independent repair shops. And the assumption here is that anything standing in the way of repair opportunities must necessarily harm the public good. But these tools, parts, and know-how are often protected by IP rights, such as copyrights and design patents. And we protect copyrighted works and patented inventions because, as the Constitution recognizes, this promotes the public good. We reward creators and innovators as an incentive for them to bring these things to the marketplace. And the public benefits from the introduction of new products and services that increase competition. Thus, the right to repair movement isn't based on a pre-existing right. It's instead asking lawmakers to create a new right at the expense of the existing rights of IP owners. And there have been several bills introduced at the federal level, and they generally take one of two approaches. So the first is to rewrite the Copyright Act or the Patent Act in a way that directly limits IP rights. So this is the approach with the SMART Act and the Freedom to Repair Act. The second approach is to define the normal exercise of IP rights as an unfair or deceptive practice to be enforced by the FTC. This is the Repair Act and the Fair Repair Act. Of course, the FTC already has the authority to address unfair or deceptive trade practices. And it's noteworthy that even after promising to crack down on this 2 years ago, the FTC has not brought such an enforcement action against a manufacturer, though it has brought a few actions related to warranties. So I submit that the reason for this is simple. IP owners are merely exercising their federally protected IP rights, and this is not actionable anti-competitive conduct. It is instead how the IP system is supposed to work. We grant IP owners exclusive rights so they can exclude others. And this in turn promotes the investments to create and to commercialize these creative innovations in the marketplace. And that promotes the public good. And as tempting as it may be to take away or limit IP rights so that others can copy and then call that competition, I would urge the members to think about whether that truly represents sound economic policy. The fact that the definition of unfair or deceptive practices would have to be changed shows that it's not really a competition law problem. I would recommend against micromanaging the free market system to pick winners and losers. The market does a great job of sorting this out already. And with that, I again thank you for the invitation to speak today.
Thank you. Please.
Chairman Issa, Ranking Member Johnson, and members of the subcommittee, thank you for the opportunity to speak with you all today. My name is Aaron Perzanowski. I am a professor of law at the University of Michigan, and for the last 15 years, my academic research has focused on the intersection of personal and intellectual property rights in the digital economy. During that time, the right to repair has emerged as a central challenge to the notion that we as consumers control the devices that we buy. Instead, consumers, farmers, small businesses all find that manufacturers exert post-sale control over these devices, often in ways that frustrate repair. Repair is as old as humanity. Our Paleolithic ancestors repaired hand axes and other primitive tools. And as our technologies have grown more complex, from the Bronze Age through the Renaissance to the high-tech devices that we all have in our pockets here today, repair has always kept pace. But today, manufacturers are employing a range of strategies that restrict repair, from their hardware and software design choices to clampdowns on secondary markets. And we also troublingly see attempts to leverage IP rights as tools to restrict repair. These efforts are a major departure from the historical treatment of repair under the law. The right to repair is not only consistent with nearly 2 centuries of IP law in the United States, it reflects half a millennium of common law property doctrine that rejects post-sale restrictions on personal property. As early as the 15th century, English property law recognized that once a property owner sells an item, efforts to restrain how the new owner of that item can use it are inconsistent with the essential nature of private property and obnoxious to public policy. As the Supreme Court has repeatedly recognized, IP law's respect for the property interests of purchasers of copyrighted and patented goods was profoundly shaped by this common law tradition. In 1850, the Supreme Court recognized that the repair of a patented machine reflected, quote, no more than the exercise of that right of care which everyone may use to give duration to that which he owns. A century later, the court held that the repair of a convertible car roof was justified as an exercise of, quote, the lawful right of the property owner to repair his property. And just a few years ago, the court reaffirmed the rejection of post-sale restrictions under patent law in Impression Products versus Lexmark, a case about refurbishing printer ink cartridges. Copyright law, not surprisingly, has had fewer occasions to consider repair restrictions, but as early as 1901, the Seventh Circuit recognized, quote, a right of repair or renewal under US copyright law. When a publisher sued to prevent a used book dealer from repairing and replacing damaged components of books, the court said that, quote, the right of ownership in the book carries with it and includes the right to maintain the book as nearly as possible in its original condition. A century after that, Congress itself acknowledged repair as a right that owners enjoy regardless of copyright restrictions when it enacted Section 117C of the Copyright Act. That provision was designed to undo a Ninth Circuit decision that allowed copyright holders to prevent third-party repairs of computers. Section 117C explicitly permits owners of machines to make copies of computer programs in the course of maintenance or repair. And finally, the US Copyright Office over the last decade has repeatedly concluded that diagnosis, repair, and maintenance activities are non-infringing when it comes to vehicles, consumer devices, and medical equipment. So the right to repair is firmly rooted in basic principles of US IP law. But IP law can and does continue to interfere with repair. Kyle talked about overbroad copyright claims over service manuals that limit access to crucial information. Section 1201 of the DMCA makes it practically impossible for consumers to exercise their lawful right to repair a wide range of devices, from tractors to home electronics, even though the Copyright Office says those activities are non-infringing. And the weakening of standards for design patents allow firms to choke off the supply of replacement parts needed to repair vehicles, home appliances, and other devices. So I thank you all for your interest and your leadership on this issue, and I'm looking forward to your questions.
Thank you. We'll now go to Mr. Fitzgerald for the first 5 minutes of questioning.
Thank you, Mr. Chairman. Mr. Benavides, the May 2023 Consumer Price Index showed that the cost of car repairs was up almost 20%. The National Auto Dealers Association found a similar kind of number with new car dealerships, service and parts sales totaled more than $137 billion in 2022, which is again up from $125 billion in the year before. This could be attributed to a number of factors, including the inflation that we're all well aware of. Also, used and new car shortages, the complexity repairs, of course, which is what we're discussing, or just the labor shortage when it comes to maintenance technicians, kind of across all industries. Supporters of the chairman's bill, the SMART Act, argue that consumers could save as much as $500 by repairing their vehicle with an aftermarket part versus a dealer. Now, that seems low to me, but that's the number that we're using. So, Mr. Benavides, what are your strategies when you're trying to deal with the part shortages and the shortage of OEM parts compared to the shortage of aftermarket parts? What's kind of happening on the street, I guess, is what I wanted to know.
So through the pandemic, we had seen some OEM companies not have as many parts in stock as we used to. That has gotten significantly better. We support a competitive marketplace. We want competitive parts in our industry. But if you don't have the quality and safety aspect in them, if you just, in the SMART Act, it says similar appearance, right? If that's the only thing you're worried about, they're not apples to apples. We put on parts every day to secure my family, your family, in the next accident. When those parts lack the testing and the credibility to be on those vehicles, that's what hurts our shops, right? So we want that competitive marketplace. We just wanted to add quality and safety to it.
Very good. Switching topics here, Mr. Perzanowski. In the northern part of my congressional seat, John Deere Horicon Works exists, which is for the most part a factory that does most of John Deere's lawn care line. And we were pleased in January to see that the American Farm Bureau Federation and John Deere had signed a MOU. And basically the MOU guaranteed farmers and ranchers the right to repair their own farm equipment. And that obviously extends to other products in the John Deere line. But it's still too early to see kind of how this MOU is going to function or how it would work. But could you explain kind of what an MOU can do in this type of situation and what it does and what it doesn't do as far as farmers and ranchers?
Yeah, thank you for the question. So I think MOUs, these memoranda of understanding, which are private agreements between stakeholders in various industries to abide by a certain set of contractual provisions, can be helpful under certain circumstances. There was an MOU in 2014 that grew out of the Massachusetts auto repair law that I think has been very effective, not perfect, but effective. I think there are a few things that you need to see in these MOUs in order for them to be helpful in this situation, right? One, we need real buy-in across the industry. The MOU that was signed last week in the auto industry does not represent a significant portion of the independent repair community. John Deere is one company among a handful that dominate in the agricultural space. So even if they agree to a certain set of rules, that doesn't solve the problem industry-wide. It's really important that there is some enforceable legal set of rules here so that these things have real teeth. That's part of the reason things worked well in Massachusetts. When companies can just sign voluntary agreements that allow them to walk away at any point, that doesn't have a whole lot of meaningful enforcement behind it. The Deere MOU is also problematic, I think, on its substance. Deere agrees to provide one software tool to farmers, but as a report issued today by US PIRG demonstrates, that particular software tool is insufficient. It doesn't solve the problem that farmers have when it comes to initializing replacement parts, the part pairing issue that was referred to in some of the earlier statements. So I think they can be a useful tool, but oftentimes, frankly, I think they're designed to generate good PR and to confuse arguments around the need for legislation. So I think we have to look at them with some skepticism.
Thank you very much. I yield back, Chairman.
I thank the gentleman. We now recognize the ranking member of the subcommittee, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. Professor Perzanowski, Professor Hartline says that owners of property don't have a legally enforceable right to repair that property. Do you agree with that statement?
So I take a different view here. So we can define the notion of a right in a number of ways. I don't want to bore you with property theory and talk about Hofeld and give people who went to law school terrible flashbacks. But one way to think about a right is as an affirmative power to force someone else to engage in some behavior. And in some cases, that is what we're talking about, right? We're talking about imposing, especially on the state level, regulations that impose requirements on manufacturers. I think that's true of the Repair Act on the federal level as well. But I think part of what we also need to keep in mind is that sometimes what you need to effectuate a right is to eliminate barriers that stand in the way of that right. So we can think about this, I think, helpfully in the context of tools that enable people to engage in repair. The state level solution has been to require manufacturers to give their own tools to repair shops, sometimes compensated under fair and reasonable terms. The other solution would be to change Section 1201 to say, let's allow independent repair shops to make their own tools. I think both of those solutions have some value to them. I also think it's really important to keep in mind that when we're talking about IP rights, there are always multiple sets of interests at stake. And one of the key balances that IP law has always tried to strike is the balance between the limited statutory exclusive rights that the Patent and Copyright Acts create and the personal property rights of consumers who own these devices. And so I think a balancing is absolutely necessary and appropriate.
Well, tell me, what precisely do you recommend Congress do to limit the scope of Section 1201, which you seem to be advocating?
So I think the best solution for Section 1201 is embodied in a piece of legislation that Representative Jones and Sparks introduced in the last Congress, which would create a permanent exception to Section 1201 for repair that would apply not only to the act of circumvention, but would also apply to the creation and distribution of tools that are useful for repair purposes. That does not open the door to a sort of broad, unrestrained creation of circumvention tools, but tools that are targeted to the repair market.
Professor Hartline, what is your take on this discussion?
So I think even the cases that my friend cited, the 1850 case, the Supreme Court case in Arrow, they all make the distinction between repair, which is permissible, and reconstruction, where you actually recreate the patented device, which is not. And so it's definitely a right of IP owners to prevent other people from practicing their invention or copying their works.
Do they have a right to prevent repair of that personal property?
No. So he cited a case about where you can repair a cover on a book. That's very different than recreating the book, every single word in it, right? So there's a difference between repairing something and then crossing the line into violating the exclusive rights of IP owners in the patented product or the copyrighted book. And so the things that repair supporters are asking for is that, okay, if somebody has a design patent that covers an auto body part, well, they have the right to exclude other people from making that part. But repair supporters say they shouldn't have that exclusive right because, we could increase competition if we just took away their design patent and now other people could make that part, and so that's competition. But that's not the type of competition that IP law and competition law seek to support. That's like saying if we just let the Pirate Bay copy and distribute all of the Disney blockbuster movies, then that's competition and prices would go down. But that's not the way that we do it, right? So competition means other people come up with new products and new services. And so that's what we should be trying to support.
Thank you. I yield back.
Thank you. Mr. Benz.
Thank you, Mr. Chair. And I think I'll ask this question of Professor Brzezowski, and it's this: if you're told at the time you're buying an Apple product that you can only have it repaired by Apple, aren't you adequately informed that you will need to go to that one place and indeed may have to pay twice or even 3 times for something you bought once? What's the justification then if you were fully advised? No one reads that 50-page contract at the beginning, but let's assume by some miracle you did. Then why should the right to repair interfere with that full disclosure?
Thank you so much for the question. So I would begin by pointing out, as you do, that consumers are often not informed about the terms of these sorts of transactions, right? When you're presented with a 10,000-word license agreement, most consumers, and I think rationally, don't engage with those documents. They're designed to be difficult to read and difficult to understand. And so oftentimes consumers are lacking that kind of clear disclosure that I think they need in order to make informed decisions.
Right, but of course, I took that off the table, so could you answer the question? Because I just want to know if I want that Apple product badly enough to submit, if you will, to having to pay for it 3 times, then why should we let this right, so-called right to repair interfere with that agreement?
So I think it is, it's important to keep in mind here, right, that not only do we have questions about kind of the adequacy of these sorts of disclosures, but one reason that consumers are engaging in these transactions and buying these products is because of consumer lock-in, right? A consumer who buys one Apple product is far more likely to buy another because those devices communicate with each other, offer sets of features that make it hard for consumers to break out of those ecosystems. I think it's also important that in some cases it's not just an absence of disclosure, but it is affirmatively misleading promises and statements that are being made in the marketplace. So John Deere has a history of saying lots of things.
I'm still not sure that you're answering my question, but what I'm really trying to get at is if the manufacturer of the product makes adequate disclosures and the consumer then agrees to purchase with those disclosures in mind, it would seem to me that the consumer has waived any right to make this a repair argument. But I'm going to move to Mr. Hartline for a minute. And the opponents to repair argue the right to repair law should weaken intellectual property, and I think you mentioned that. A bunch of states have passed these right to repair laws. So have you seen a noticeable decline in intellectual activity as a result of what these states are doing? And it's going to be hard to measure, is it not? But perhaps you have an example.
Well, so there's only 2 states that have passed laws related to electronic devices, and that's New York and Minnesota, and neither of those laws have really gone into effect yet. So we don't know what's going to happen. What I suspect is going to happen is, especially in the Minnesota law, which doesn't have a carve-out for federal IP protection, is that there's going to be litigation over that law based on the idea that it's preempted by federal copyright law and patent law. And the reason is because the Minnesota law tells IP owners that they have to turn over their IP protected things, and federal law says, no, you get to keep those to yourself. And if you don't mind, I do want to talk about the idea that people know going in. Like, I bought an iPhone, and I didn't read the 10,000-word thing, but it's the point that you're making is, as long as there are adequate disclosures and there's no fraud on the public, then these are not competition issues, and there's just nothing wrong with it.
I want to go back to one of the elements of this discussion I was researching over the weekend, and it was this. The interest I have in knowing where the 30 months comes from and knowing how you measure the value of the idea and then suddenly say we're going to protect it for 30 months. And
I'm sorry, the 30 months in the SMART Act?
Yeah, sure, sure.
I'm not an economist, and that does seem arbitrary. And I mean, the term right now for a design patent is 15 years. I don't know how to say what the optimal term is, but I do think it's a bad idea to take away people's design patents so you can let other people make exact copies and then say, oh, that's innovation.
Thank you all for being here. Yield back.
Thank the gentleman. We now recognize the ranking member of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Mr. Benavides, I was deeply concerned to see the original equipment manufacturers react to the Massachusetts right to repair ballot measure by suspending access to telematic accessories for vehicles sold in the state. How will the recent agreement between repair shops and OEMs affect consumer choice going forward?
Thank you, Congressman.
And are you concerned that we'll end up with a patchwork of state laws governing right to repair?
This agreement with the OEMs is great for us because we finally get to put to rest the fact that we don't have information, right? That we weren't able to get information. So this is an agreement that we've worked on for a while to make sure that we have access to all information, including telematics and anything coming forward. It's in there that the commitment for both parties to support legislation if it needs to get there, but we would like this thing to stand on its own. This agreement has been needed for some time. We stand on the front lines of repairing these vehicles. We need this data, and we have this data. Right now, we have zero repair shops asking us, hey, we don't have the data, we can't get the data, we don't know how to fix it. We don't have that right now, Congressman.
But how will this recent agreement affect consumer choice?
What it will do is make sure that the consumer has the right to take it to a shop that has this access and can repair these vehicles properly. The consumer is, I don't want to say it, the consumer, when they come to my facility, the consumer does not know a lot about the choices that we get and what we have to do behind the scenes. They do not have that, they do not have that understanding. They look to us, they only get in an accident once every 8 years. So they rely on us to have that information. They rely on us to repair those vehicles properly.
Thank you, Mr. Roberts. Same question. Same question.
In regard to like what impact that will have on repair?
How will the recent agreement between repair shops and OEMs affect consumer choice going forward? And are you concerned that we'll end up with a patchwork of state laws governing the right to repair?
Well, first of all, the agreement, as was mentioned, does not represent the vast majority of aftermarket service providers, and therefore, you know, I think mostly performs a sort of, you know, public relations role rather than a functional role in terms of how the aftermarket will work. You know, is there concern about a patchwork of laws? Well, I think for consumers who are, you know, bending and breaking under the cost of high vehicle repairs and struggling to maintain their vehicles, they would rather have a state law than no law at all. So I think, yes, of course, from everybody's perspective, it would be better to have one federal law that applies across the country.
Thank you, Mr. Hartline. Repair advocates argue that Section 1201 prevents non-infringing circumvention of access controls for repair purposes. But Congress contemplated this use when it passed the DMCA in 1998, allowing for a triennial exemption process. Is the exemption process working as intended? And if not, are there actions Congress can take to expand exemptions or make them easier to acquire?
So what's important about the triennial rulemaking is that the proponent of an exemption has to come forward with evidence and demonstrate that there's actually a problem and it relates to a certain class of works, and then they can get a temporary exemption for 3 years. And so it is true that the Copyright Office, well, the library permanent exemption that opens things all the way up with access controls, copy controls, and trafficking thereof, is now you're getting to the point of why we even have these TPMs under 1201 in the first place, and that's because they guard against piracy. And so the concern is that you're opening the piracy floodgates, you make these devices less secure, and then content owners are going to be less likely to want to put their content on these devices.
Thank you, Mr. Chairman. My time has expired. I yield back.
I thank the gentleman. We now go to Mr. Klein.
I thank the chair for holding this substantive and stimulating hearing. I had a farm conference yesterday with the secretary or the chairman of the Ag Committee, and it's timely we're having this hearing today because in January of this year, the Farm Bureau Federation and John Deere signed an MOU that purports to guarantee farmers and ranchers the right to repair their own farm equipment. So right now we're kind of in a wait-and-see mode, but it's very interesting that it's kind of across industries. But I'll ask Professor Perzanowski, how does Section 1201 of the DMCA impact the ability of consumers and independent repair shops to modify or repair devices that have proprietary software and data in the consumer electronics industry?
Thank you so much for the question. As we've been talking about, the Copyright Office in 2015, 2018, 2021, and they're in the process for the current rulemaking, has determined that engaging in circumvention, the removal or bypassing of these digital locks for purposes of repair is perfectly lawful behavior. But there is a major practical mismatch here between the legal rights that consumers enjoy under federal law today and their practical ability to exercise those rights. And that's because, as Devlin was just describing, the Section 1201 rulemaking does not extend to the creation or distribution of tools, right? So I have the right under federal law to remove the technological locks, say, on my video game console if I want to swap out a broken disk drive. How do I do that? I like to think of myself as a pretty technologically sophisticated person. I don't have the first clue about how to do that. I need a person who can write that code, make that code available to consumers so that I can. All I'm trying to do is swap out a broken disk drive on my video game.
But you would argue
console.
that code is proprietary, correct?
So I'm talking here about a third party making their own code, right? Okay. That is simply allowing me to engage in activity that the Copyright Office has repeatedly said is non-infringing.
Do you want to give them a map? Is that essentially what
Absolutely, yes, I do.
Do trade secrets play a role in the right to repair debate?
There are occasions where trade secrets are important. I don't think in the context that we're talking about here with Section 1201 that we're typically running into trade secret issues. The state level bills that have been introduced do typically address trade secrets and often have carve-outs there, and I think that's something worth considering in this debate. But I think it's important to keep in mind that, like, just because we have some hypothetical worry about some unknown bad actor taking a tool that I use to fix my video game console.
Well, it's not unknown. The Chinese do it all the time.
I don't think the Chinese are particularly worried about whether or not I can fix my video game console. And in fact, I think that point is important. But the bad actors already have these tools. All we're trying to do is get very targeted tools in the hands of law-abiding citizens who just want to repair the stuff they buy for their kids for Christmas, right? If the Chinese are going to hack the PlayStation, they've already done it.
What role does the Library of Congress and Register of Copyrights have in granting exemptions to Section 1201, and how does this process relate to right to repair?
So the 1201 process is what established the legality of circumvention for repair purposes. But when Congress created that rulemaking authority, it only extends to the act of circumvention, right? The actual removal. Congress did not give the office or the librarian the authority to grant exemptions to the trafficking provisions. And that's where I think legislative intervention is really important.
Do you think state-level right to repair laws are having a positive or negative or just a complicating impact on ensuring that we safeguard IP protections for OEMs while also allowing consumers to repair their own products?
So I think right now it's probably too early to say exactly what impact those state laws have had. Like, this is all very new. I think we can say with some confidence that in a state like Colorado, which enacted a motorized wheelchair right to repair law, that has had major practical advantages for folks who rely on those devices. They were waiting around for weeks and weeks and weeks for authorized repairs, and now they have the opportunity to have those devices that they rely on fixed in a more timely manner. The longer-term consequences, I have my own predictions, but I don't think I can say with confidence what that landscape looks like today.
Thank you. I yield back.
Thank the gentleman. We now go to gentlelady, Ms. Ross, for 5 minutes.
Thank you, Mr. Chairman, and thank you to all the witnesses for your perspectives. This hearing provides an important opportunity for all of us to learn more about the right to repair and the role of intellectual property in the equipment that we purchase. The issues we're discussing today clearly are complex and involve numerous industries with different sorts of patents, and your perspective might be different based on the industry and the type of patent involved. Ultimately, there may be no one-size-fits-all solution for repair, particularly given that some misrepairs could jeopardize the health and safety of users, while others would not. And for that reason, it seems to me that regulations that govern, say, the repair of an airplane or an X-ray machine should differ from the regulations for the repair of ordinary household appliances or even maybe a computer. And so I want to ask a question first to Mr. Przanowski and then Mr. Hartline after him. My district is home to many medical device manufacturers, and they're on the front lines of innovation. I want to make sure we encourage research and development while safely repairing machines when they break. So should there be a different repair standard for life-saving equipment versus for an everyday household item?
Thank you so much. It's a really important question. I think safety and security have to be important concerns anytime we're talking about repair, regardless of who is making those repairs, whether it's an independent shop or an authorized providers. And I think you're absolutely right. Those risks are more salient when we're talking about medical devices. But to the extent we are concerned about those issues, I don't think IP law is the right set of tools to use in order to ensure high quality repairs. Volkswagen held all of the IP rights in its Dieselgate vehicles. Abbott held all of the IP rights when they had to recall 500,000 pacemakers. So I don't think the identity of the IP rights holder is what's going to get us to safe and secure repairs. So I think the question is, how do we do that? That's frankly, it's beyond my expertise, but I would turn to the real experts here. The FDA issued a report in 2018 that concluded that independent repair of medical devices is safe and effective. I haven't seen evidence that runs to the contrary there, but if I do, I'm certainly open to it, and I do think we have to have a really important conversation outside of the IP context about how we make sure that these repairs are safe.
And who's responsible if they're not?
Absolutely.
Mr. Hartline, briefly, because I do have another question.
Yes, thank you. So I agree with medical equipment. That's when it's more important than ever that the right people are doing the repairs. And so we saw in the recent rulemaking at the Library of Congress that there was an exemption granted temporarily for medical equipment, and now there's a lawsuit that's at the DC Circuit right now, whether, it's kind of about whether it's a good idea, but it's mostly about, whether it violates the APA. But what I would say is there's absolutely nothing wrong with manufacturers parlaying their IP rights into repair opportunities. This is how they get more money, and they can invest that money, more R&D, more investment, more innovation. And so this is just part of a business model that IP supports, and there's absolutely nothing wrong with it. And a benefit is the right people are fixing it.
Thank you. Mr. Wiens, I wanted to talk to you. I loved your story, but I'd like you to share with us whether you think that there are any cybersecurity implications for the right to repair.
Well, across the board, the question is, who should we be able to inspect what is happening with these devices? What we have found is that when you have access to some amount of repair information, it makes information available to cybersecurity researchers who are able to do better work. We've found, I mean, I write software, iFixit has had vulnerabilities in the past, and when we work directly with researchers and they give us feedback and we improve it and we fix those problems. So when you have a little bit of sunshine on what's happening, that enablement of security research is really profound. And we've actually talked about, one of the challenges with Section 1201, it doesn't just ban repair tools, it also bans the distribution of cybersecurity tools. And so we've seen security researchers, Apple sued a company that made a security research tool under 1201. And that tool has markedly made the world more secure. It's very popular amongst government security researchers. So I think that's kind of the sweet spot is allow some third-party inspection. It'll make the product better.
Thank you, Mr. Chairman. I yield back.
Thank you, and thank you for your round of questioning. Mr. Fry.
Thank you, Mr. Chairman. You know, it's July in South Carolina, and people are flocking in from all over the country to vacation. And I'll tell you something, that one of the most profound disappointments in life is when you go to a McDonald's or other fast food establishment and you want to get a cold ice cream, an ice-cream on a hot summer day, and your hopes and your dreams are dashed because the machine is broken. Who, and I know this is kind of out of order, but who here has experienced that? Show of hands. Pretty much everybody, unanimously, right? And so you're disappointed because it's hot and you assume one of two things. You assume that the employees don't want to make the ice cream, or you assume that the franchisee doesn't want to provide that because of something. But in reality, according to Mr. Wiens, your op-ed, it goes much deeper than that. There's 1201 section issues that pertain to this on who can fix the machine so that customers like me can get that great Frosty from Wendy's or McFlurry from McDonald's. Real quickly, Mr. Wiens, just, and Mr. Chairman, with unanimous consent, I'd like to enter into the record Mr. Wiens' op-ed, Congress is preventing us from fixing McDonald's ice cream machines.
Without objection, so ordered.
But I think it's really important, and Mr. Fix-It, if you can you elaborate on how current restrictions on the right to repair affect the average consumer, in particularly touch on the cost and the convenience for the consumer?
Well, first, let me say it's not the poor McDonald's employee's fault. It's the machine's fault. So these ice cream machines are made by a tailor, and there is an incredibly complex Baroque set of touchscreens you have to go through, and then there's a service password that you have to be able to get past in order to access the settings that really allow you to do what you want. And so in an ideal world, you'd have an entrepreneur who would come along and make a tool to make it easier for McDonald's. Maybe they'd have an app on their phone that they could use to configure and help them diagnose and repair the machine. Unfortunately, the company who made that tool is struggling legally because of all of these challenges. Across the board, if we had innovation outside of the manufacturers and to be able to develop new tools for fixing ice cream machines or anything else, you'd have a whole flowering ecosystem of repair tools. Right now, it doesn't exist. The US is like this black hole where innovation is banned in software repair. I can't, there's all kinds of opportunities I could see. I had a farmer ask me for help fixing his John Deere tractor, and I had to say I can't do that particular repair because it's illegal. I'd love to build a cool app for helping him diagnose and fix his tractor and get back in the field faster. We don't have that marketplace right now. It's like farmers have been forced to use cracked Ukrainian versions of John Deere's diagnostic software.
Right, so it's not, I mean, it's not just ice cream machines. I led off with that, but it's farmers, it's farm equipment, it's iPhones, it's somebody's Xbox, right? I mean, these are all things, in your experience, what are the challenges that these customers and stakeholders face when they're trying to repair their own devices? What are some things that they face?
It's absolutely infuriating if you're, okay, so my friend, farmer in San Luis Obispo, Dave grows all kinds of amazing products. He has a $300,000 John Deere tractor, came to me and said, hey, there's a bad sensor. It's gonna take a week to get that sensor sent out from Indiana, and I need to use the tractor in that time. Will you help me bypass the sensor? I could hypothetically modify the software in the tractor to do that. Practically, I didn't have the legal ability. And so he had to go and rent an expensive tractor for the week. This is impacting people's lives every single day.
Right, so, and to pivot a little bit, what role do you see from a federal side, from legislation, and what specific measures do you think might be included in such legislation?
Yeah, so we've seen kind of the solutions being approached from two angles. At the state level, you have states saying, John Deere and other manufacturers, if you have a dealership that has fancy tools, sell those tools to consumers and to independent shops, allow that competition. At the federal level, what we can do is enable a competitive marketplace for those tools. So rather than compelling John Deere to sell the tool, we could say, hey, it's legal for someone, an entrepreneur, to make a competing tool. And you have this in the car market. You can take your car down to AutoZone, you can buy a scan tool, plug it into your car, and it'll decode some of the error messages. Those tools exist in the auto market because we have a standard diagnostic interface on cars that you can access without circumventing a TPM. We don't have that for any other products. So another farmer in my town, he showed me how if he has a transmission go out on the truck, he can fix that. But if he has a transmission go out on his John Deere tractor, he can't. He can physically install the transmission, but he can't program it to make it work. I'd love to be able to make a software tool to enable him to replace his transmission.
Thank you, Mr. Chairman. I yield back.
Thank you. We now go to Ms. Lofgren for her round of questioning.
Thank you very much, Mr. Chairman. As I've listened to this testimony and the questions, a couple of things come to mind. First, what we're looking at, and you and I have talked about, is relief for design patents in automobiles. It has nothing to do with utility patents. I just thought it was important to note that. And then as to adequate disclosure, I remember when we were talking about this in the 1990s, a situation where a nonprofit had put on like page 25 of their disclosure, if you've read this far, we'll give you $1,000. And no one collected the $1,000. So it's not really, most of these are not meaningful disclosure. I just think it's important to go back to 1998. Only the ranking member and I were here at that time, on what we were trying to do with the DMCA. And at the time, we were concerned, and I think rightly so, that there was theft of copyrighted material, songs, movies, and the like. And the protection that was being advanced was to preclude hacking in to that copyright protected material with TPMs. And I was for that. I thought that was a good idea because that piracy was improper and wrong, and this was a way to solve it. At the time, though, I remember raising the issue, what if these TPMs are going to be used to protect non-content? You know, and we ought to address that. And we didn't come to an agreement on that. The compromise was to have the Copyright Office revisit this periodically for relief should that occur. And I think it's been pretty clear that process has not worked perfectly well. In order for them to pay attention to something, there has to be a huge stink in the country. For example, the monopolies on cell phones, people were upset about it. We had a hearing about it, so finally they dealt with that. Other monopolies, you know, we didn't do TPM so monopolies could control products. That was never the intent. So I think the process didn't really work as we've intended, and the process has to do with the lack of scope as well as tools. We left the tool part out when we did the DMCA, and so I guess the question is, and maybe Professor, you could address this, could we craft a measure that allows for tools to disable TPMs when the TPMs are being used not for content protection as was intended, but to promote essentially monopolies through products? Is there a way to do that? And then the other thing is cybersecurity. Is there a way to narrowly define an exemption for cybersecurity? Because that would be very helpful for society at large. And by the way, I think would help reform the CFAA, which Congressman Sensenbrenner and I tried to do a number of years ago. We didn't get any traction, but the misuse of the CFAA for legitimate researchers continues to be a problem. Can you suggest ways that we could narrowly craft a change that would still protect content holders?
Thank you so much for the question. I'm a little reluctant to try to start drafting statutory language on the fly. But I think the point you raise is a really important one. And I think that the previous proposals about creating new statutory exemptions for repair purposes go a long way to limiting the scope of Section 1201 beyond the kind of entertainment content that was originally Congress's goal to protect. And I completely agree with your kind of recounting of that story. There are existing statutory exemptions in Section 1201 that I think can serve as a useful model. They are very narrow. I would like to see some of those expanded. They go to encryption research, security testing,
Right.
There's a law enforcement exemption. And I think looking at the existing language can be a helpful model for a repair exemption and also for addressing some of those cybersecurity concerns that you
At the time that we wrote it, we weren't really envisioning the Red Hat movement that we see today and the utility that that has provided for more secure software. And we did the best we could, but it was 1998 and a lot of things have changed since then. Mr. Chairman, my time has expired, but I'm hopeful that we can address this issue, protect the content that we always wanted to protect, but let people own the things they thought they owned instead of finding out that it's only a lease. I yield back.
I thank the gentlelady. I now ask unanimous consent for the record that the documents from the National Association of Mutual Insurance Companies, documents concerning the new YouGov poll, it's a one-pager, the YouGov poll release itself, the SMART Act white paper, the Repair Act white paper, the Vehicle Suppliers Association documents, and the attached documents in a compilation of letters in opposition to the announced MOU for groups representing more than 200,000 repair shops of the ASA, ASA representing 1,000 shops total, be placed in the record, and a survey that demonstrates strong support for federal vehicle right to repair legislation be placed in the record. Without objection, it's all in. We now go to the gentlelady, Ms. Lee, for her questioning.
Thank you, Mr. Chairman, for hosting this important hearing today and for your leadership on this issue. I am proud to join with you in this subject. And I'd like to begin with returning to you, Professor Perzanowski, on this question. Obviously, one of our concerns is the rising cost of repairs when coupled with the rising cost of vehicles, how this affects consumers. And I'd like for you to talk with us about the effect that you anticipate passage of the SMART Act might have on insurance rates for consumers and whether it is something we should anticipate a decrease in rates, lower costs as parts and repairs become more accessible for consumers.
Thank you so much for the question. So I think if we see passage of the SMART Act, we can anticipate significant reductions in the expenses associated with auto collision repairs. Estimates are that design patents on collision parts are responsible for about $1.5 billion in additional expenditures. We see price premiums on OEM parts over third-party parts often reaching into like the 40% range, right? So these are pretty significant cost savings associated with that. Part of this problem, I think, does relate back to the kind of unique structure of this market. Most consumers are not paying out of pocket for collision repairs. Those costs are being covered by their auto insurance provider, and so the consumer doesn't see that I'm pulling this from memory, so don't hold me to this figure, but the side view mirror of a Ford Fiesta costing $1,500 That's not something that the consumer is confronted with, right? So this goes back to the question of notice. Do consumers know when they buy that vehicle that the repairs are going to be that expensive? I think in most cases they don't. And so I think the SMART Act is a very targeted solution to this problem. I do think it's important to note that the design patent issue for replacement parts is not limited to the automotive industry. I think it's the most, I think that's the area where the problem is most pressing. But home appliances, consumer electronics, we see companies getting design patents on replacement water filters for refrigerators so that they can charge 3 times as much when the little light comes on your fridge to tell you that your water might not be as clean as you want it to be. So I think we have to think about that problem across a range of industries, but the automotive industry, I think, is absolutely the right place to start.
All right. And staying with the automotive industry and the concept of the SMART Act, would passage of the SMART Act, in your view, promote entry into the repair market of more mom and pop or independent shops? And if so, how would that advantage the end consumer?
So I think in an environment where consumers are facing lower costs for repairs, and fewer vehicles are being totaled, right? One of the byproducts here of the high prices of these replacement parts is more and more vehicles are being totaled. So we would see more opportunity for competition in those marketplaces. And generally, right, we rely on this principle that the more competition we see, the lower prices are going to be and the higher quality is going to be. And so I think that's beneficial.
And Mr. Roberts, you look like you had something to add there.
No, not really. I mean, I think that what Aaron said is correct, which is, one of the key goals of right to repair legislation is to promote a vibrant ecosystem of service and repair. I mean, one point I would just make is that with the Internet of Things, right, we are facing a crisis in the very near future as manufacturers of everything from home appliances to personal electronics to equipment, as those products age and those manufacturers walk away from their responsibility to maintain them. So we're no longer supporting the software. We're no longer issuing security updates. Who will step in to maintain those devices? Keep them secure, keep them operating, right? The manufacturers walked away. Do we just get rid of them? No, because the equipment still works perfectly. We're going to need a market-based response to that. We're going to need small businesses to step up and say, hey, I'll keep that Samsung dishwasher working for another 20 years. That's a huge economic opportunity for this country, but we cannot do it in the existing system because of the types of restrictions that we're talking about. And so this is really about enabling a secure future in which when you buy a dishwasher with a 20-year lifespan or 25-year lifespan, it's going to last that 25 years, not the 5 to 6 years that the manufacturer has decided, that's how long we want to support the software for. And there are cybersecurity implications for that as well, obviously.
Thank you, Mr. Chairman. I yield back.
I thank the gentlelady. We now go to the gentlelady, Ms. Dean.
Thank you, Mr. Chairman, and I thank the ranking member and you both for bringing us this thoughtful hearing, and I thank those who have come here to testify for your thought-provoking information and expertise. Mr. Benavides, I was interested in talking with you because I'm a little nostalgic. My grandfather, Bill Dean, had a garage in Germantown, Philadelphia, part of Germantown, Pennsylvania. Dean's Auto. His slogan was the Dean of them all. We repair everything, the Dean of them all, something like that. And how he advised me when I bought my first used car. I bought a Mazda RX-7 used. I think it had the pop-up lights and an electric, it was a great car, rotary engine, remember? An electric antenna, and he warned me. He said, Mad, when you do that, you're gonna wind up with more repairs. More gadgets, more repairs. Well, that didn't stop me. I loved the car. It was a lot of fun. I was thinking of you. Bring us up to speed. If my grandfather were here today, what is it like in your repair shop, your body shop, your repair shop, with the challenges that come in as a result of a vehicle breaking down or being backed into, whatever it is? What's happened in the last 10, 20 years?
Thank you, Congress Lady. you would be astounded at what we face on a daily basis. We're dealing with more crash parts, more electronics, more lane departures, more, I see that guy in the commercial when he's clapping his hands as he's driving that vehicle. I have to put that vehicle back on the road after it gets in an accident so he can clap again as he goes down the road. It's very difficult. It's a scary business to be in. Sometimes I go to industry events and I come back to my dad, who's still working at the shop, and say, Dad, it might be time for us to get out of this, because it is scary how and put my kids in the car, put your kids in the car. And we have lane warnings, and we have departures that we have automatic braking now that we have to make sure is correct. There's an emblem inside the Toyota, at the front of the Toyota, that's a radar emblem. If we don't put the correct emblem on that vehicle, that car can get in an accident again quickly, right as it leaves my shop. It's very disturbing what we have to go through.
So essential to you, for your peace of mind and your ability to do your job well, is the repair data, very transparently. Is that correct?
Absolutely. It's the one thing we count on. From when it comes into my shop, we look up repair data to fix the vehicle. When we check it in to get it to the repairer, inside the shop, we look at the repair data. When we give it to my technician, we look at the repair data. When it gets out of his hands, we look at the repair data. When we return it back to the customer, we have to scan it again and make sure we look at that repair data. So we're constantly needing that data to repair those vehicles.
Thank you very much. Mr. Wiens, in your written testimony, you concluded, quote, a robust repair market creates and expands job opportunities in the United States, keeps reusable, repairable products out of the waste and recycling streams, and gives consumers more options for what to do with a malfunctioning product. I'm in favor of all of those things. How do you respond to the suggestion that the right to repair is harmful to U.S. businesses, is harmful to content creators?
Well, I don't think the right to repair has much to do with content creators, but it really is it's a balance between big business and small business. The question is who gets to decide what happens with our things? Who gets to decide at every step of the way? And I've worked a lot with Apple products over the years, and Apple's perspective is that they want to be the one to decide. Right now, Apple has a repair program, but you have to, in order to do a repair, you have to give them your serial number ahead of time, and they decide. They basically give explicit permission. When the repair tool phones home to Apple and says, "Can I do this repair?" Apple says, "Yes, the serial number is authorized," and they allow just that repair. And if I wanted to do that same repair on that phone the next day, I wouldn't have permission. So small businesses need the ability to innovate. I'm going to be, tomorrow I'm going to be at a repair shop in Minnesota called Repowered, where they take disadvantaged folks who didn't have economic opportunities. They use iFixit guides, they train them to do repairs, and they're taking discarded electronics, fixing them, and selling them in the community.
Very interesting. Thank you. I yield back.
I thank the gentlelady. We now go to the gentleman from California, Mr. Kiley.
I yield back to the chair.
Yielding to the chair, I will use that time. Today, we're primarily talking about Section 8, Clause 8. I'll read it because it's short. Patent and copyright clause. It says, the Congress shall have the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. Mr. Hartline, I'm going to start with you. On a design patent, what's the discovery?
So a design patent is a new, original.
It's an ornamental
design.
And is it true that the United States is one of the few countries that actually recognizes ornamental designs for purposes of a 15-year exclusion?
I'm not familiar with international patent law. I'm sorry.
Okay, well, let's just say
it's been recognized here for over a century.
Right, we've had them for a period of time. They've had different periods and so on. But because they're ornamental in nature, does each part have to be uniquely ornamental, or does the Patent Office, to your knowledge as a professor, do they grant it based on what appears to be a distinctive, different design than the one that came in the day before?
I'm not a design patent law expert. When I taught patent law, I covered utility patents. I skipped design patents. So
I don't blame you because design patents historically basically prevent your competitor from making a deceptively similar product. Would you all agree? I see the heads nodding. So much of the discussion today is, in fact, on protection that is granted by design patents. Much of what we're looking at doing is to modify, enhance, or define design patents in a way in which they do not exclude 6 or 7 or 8 years later that faded headlight that can no longer be polished to be usable from costing you $1,500 to $2,500 each in order to replace something that used to be available at the auto parts store for about $6. Mr. Roberts, you're shaking your head. Why don't you opine on that if you don't mind?
Yeah, I mean, you make a really good point, Chair Issa, and I mean, I think the point here is to focus on the downstream impact of these policies. And one thing I would point out, again, hashtag not a lawyer and also not in the auto business, but my understanding is the use of design patents has increased dramatically, even exponentially in the last 10 to 15 years. If you go back to the 90s or 80s, parts makers, automakers were not applying these types of patents to replaceable parts like bumpers and rear view mirrors. Somebody had a business decision that if you can do so, then we can capture more of that aftermarket by outlawing identical aftermarket replacements. That has a huge downstream impact on car owners and on insurers and on all of us. And so, yeah, I think you make a really valid point.
Well, in the time that Mr. Kiley has yielded me, I'm going to ask one more question that's salient to all of this, and that is, we haven't talked much about true parts. I happen to have one of Coparts, one of the major companies that recovers automobiles, totals them out, resells them, exports them, any number of uses, but generally they're receiving it from an insured in a total out. Now, historically, the founder of that company started off cutting parts off of Dodge and Chryslers and selling to people who then put them onto their vehicle and kept it running. Today, many of those items, and I'll start with Mr. Weiss, many of those items, because of the DMCA as it's presently interpreted, when you take the authentic transmission, the authentic radio, the authentic product off of a near identical make or model of a car, or for that matter, going further, even though that's not their business, an IBM computer, a Dell computer, whatever, in order to put these two original authentic products back together again, you need software which is not provided and which is being withheld. Is that correct?
That's correct. If I take a brand new iPhone 14, if I have 2 of them, and I swap the screens between those, you don't get full functionality back. You're missing a number of key features. I included in my written testimony a chart of the increase in this parts pairing over time. And so we got our start doing exactly what your constituent did. We would disassemble laptops and sell the parts. And that is increasingly hard to do. We took a MacBook Pro, we took screens between 2 of them, and it just didn't work. Without a software tool that Apple makes. Of course, I'd like to maybe be able to make an alternative software tool to Apple's, but I can't right now.
Mr. Hartline, you've been quite an advocate today for some of these issues, perhaps in opposition to what we're proposing, but would it surprise you to know that, for example, IBM buys used parts back from companies that supply them in order to keep very old IBMs with important software on them, such as the IRS, when they no longer make them, while at the same time opposes allowing that same company to sell them to companies that are not using their, quote, maintenance, remembering that the maintenance is not IBM making the parts, but in fact buying them off the market. How do you reconcile that within the questions of what I said, which was this intellectual property question that we're looking at modifying in order to create a better right to repair market?
So I'm not familiar with the IBM story in particular, but what it sounds like to me is you've got somebody who has IP protection because they created something new, something useful, et cetera, and what do? They get a right to exclude. And so they can use that right to exclude to create business relationships and to increase their profits, which they in turn use on R&D, and we get more innovation.
My time has expired. I would cite for all of us that the first use and sale doctrine says you've given off those very rights when you sell those two IBM products that now are trying to be merged. With that, we'll go to Mr. Ivey.
Thank you, Mr. Chairman, and I want to take a minute to commend you for this hearing. I greatly appreciate the opportunity to look at actual legislation that can make a difference in the lives of the American people, and thank you for doing this work. I did want to follow up, Mr. Roberts. So you had a point about, I guess, companies potentially walking away from repair obligations, which struck me as pretty important, but I hadn't really heard much about how to address that. You discussed the issue. Are there ways to, fix that problem? And then the sort of inversion of that, I suppose, is them not walking away, but the capture scenario that the chairman just mentioned, where they sort of buy up the items so that they can't be used again for resale.
So, I mean, obviously my background and expertise here is around issues in cybersecurity, so I'll defer to some of the other panelists on some of the legal and market issues. But what I would say is that both of the things that we're really proposing or talking about here, which would be changes to Section 1201 of the DMCA, as well as passage of robust right to repair laws, would empower a market-based response to keeping the Internet of Things working, secure, and functioning. DMCA 1201 reforms by making it clear that you can circumvent software locks for the purpose of repair and maintenance and upkeep, right? So that would take the threat of a federal crime away from small business owners as well as security researchers who are interested in, plumbing that software for purposes of maintenance, upkeep, and repair. And on the right to repair, by making the tools available to maintain and upkeep products, diagnostic software, schematic diagrams, service manuals available, once again, you'll be empowering small business owners to set up repair shops and say, I'm going to keep your smart appliance running for its full 25 or 30-year lifespan, and I'm going to support my family doing that locally, and not be basically choked out of business by a company that says, well, you don't have the right to access this product. From a cybersecurity perspective, that is really important, because one thing we don't want is a population of millions or tens of millions of out-of-date, unsupported, unpatched, insecure, internet-connected home appliances, webcams, home routers out there, available to nation-state actors, cybercriminal groups to compromise and use for their own purposes. And that's something we already see, particularly around broadband routers and other types of devices. And it's a real threat going forward that I think these types of changes would support.
Anyone else on the panel want to take a crack at that?
Sure, we need to find a way to get these devices secure. I like to call the Internet of Things the Internet of outdated Linux distributions. It's old software. LG's website says that you should check for security patches for your refrigerator every other month. But then the manufacturers often are not following up. They're not spending the resources. I mean, we see how often do you get updates for an Android phone? A couple years, and the manufacturers stop doing it. Google with their Chromebooks, we see schools. I heard about a school yesterday that had 20 pallets of Chromebooks that they bought during the pandemic for their students that they're having to throw away because they can't get security updates for them anymore. We need to find a way to make these things last longer, and sometimes it's incumbent on the manufacturer. We should talk about maybe asking them to make security updates available longer, but at some point also we need to take the ownership on ourselves and allow the rest of us to maintain it and patch these devices. But we do not have permission right now to patch devices. It wouldn't be legal for me to make a tool to break the lock on those Chromebooks to allow a school district to use them longer.
Thank you. Mr. Chairman, I yield back.
I thank the gentleman. We'll now go to the gentleman from Colorado for 5 minutes.
I thank the chairman. First and foremost, let me echo the sentiments of my colleague from Maryland in terms of thanking the chairman and the ranking member for hosting this important hearing, which I think is substantive and concerns an issue for which there seems to be an emerging bipartisan consensus. And so I think that the chairman was very thoughtful in terms of putting this hearing together. And of course, I thank all of the witnesses for their testimony, both the written testimony and their testimony today verbally. My home state, I represent Colorado in the United States Congress, and as you all know, and I believe it's come up once or twice here, I say this up there, that Colorado's been a leader in this regard with respect to right to repair. Last year, our state proudly enacted the right to repair for powered wheelchairs, and this year, the state legislature acted yet again by enacting the first right to repair legislation for agricultural equipment. A really big deal for farmers and ranchers that I represent in northern Colorado, northwest Colorado. They are critical steps, in my view, to protect consumers, improve innovation, spur economic growth, and I'm hopeful that other states will emulate the model that Colorado has adopted, and that, of course, we can take some lessons learned as well here in the United States Congress and potentially pursue this at the federal level. There are many of you who have worked on this. I want to perhaps start with you, Professor Perzanowski, because I know that you played an active role, my understanding, in supporting Colorado's state efforts for right to repair legislation. And I guess I wonder if you might be able to expound a bit on the benefits for our farmers, in particular in the agricultural context. I've listened to some of the debate, I'm a lawyer, so and was a chief regulator in Colorado for many years, so appreciate the very academic, and sort of almost esoteric debate that we've been having in the context of IP patent law and the different theories as to whether or not it permits the kind of right to repair legislation that we've enacted at the state level. But I like to kind of cut through all of that and get to the core of why we're here, which is it's a big deal for our farmers. It's going to have a profound impact, I think, on many of my constituents, and I wonder if you might be able to offer your thoughts, Professor.
Sure, thanks so much. In a lot of instances, this conversation, and we've touched on this earlier, focuses on cost savings, right? And cost savings are an important consideration, right? Farmers aren't thrilled that they have to pay a technician from the John Deere dealer to drive maybe hours to get to their farm and connect their laptop and download these payload files to enable their equipment to work. But in the agricultural space, the thing I hear most often in the conversations I have with farmers is, and Kyle touched on this a bit earlier, is a real concern about the time sensitivity of their work. If your tractor is out of commission for a week or two in the wrong part of the season, that is going to have disastrous effects, right? Not only on that farm's economic outlook, but collectively it can have an impact, not to be hyperbolic here, but on our national food supply. And so I think it's really important that farmers have flexibility in terms of where and how they execute repairs so that they can get their equipment back up and running. If my laptop breaks and I can't get it fixed for a week or two, I'm annoyed. There will be emails that go unanswered, but the world will continue to spin. That is not the case in the agricultural space, where I think we have to be much more concerned.
Thank you, Professor. I couldn't agree with you more. I wonder, perhaps you can talk about this in the context, and perhaps this has come up previously, of repair manuals. Do you think repair manuals are copyrightable materials?
That's a great question. So I think the copyright in a repair manual, to the extent it exists, is incredibly thin, right? So copyright law does not protect facts. It does not protect ideas. It does not protect systems or processes. And so if you look at most repair manuals, they are describing in very plain, literal language, step-by-step processes for interpreting error codes or replacing a component part. And so I'm pretty skeptical of the copyright claims that we see there. There's not been a whole lot of litigation around repair manuals. There was a case involving Gulfstream, where the court determined that the copying and distribution of those repair manuals was a fair use, and I think that's the right way to resolve that.
I see my time has expired, so I will simply say, with the chairman's indulgence, that I am a champion for the free market. I believe firmly in the competitive marketplace. I think the solutions we're discussing today and will continue to discuss after the conclusion of today's hearing are about supporting the free market and ensuring that IP and copyright law is not so distorted that we lose the forest for the trees. Because a lot of Americans out there, to the extent they're watching this hearing, are wondering how in the world a repair manual for a tractor or for a household consumer item could somehow be construed as such through a legal doctrine to us preclude a consumer, a farmer, a citizen from being able to repair that product. So with that, I yield back, Mr. Chairman, I think.
Thank the gentleman. Now recognize the ranking member for unanimous consent.
Thank you, Mr. Chairman. I have a letter from Consumer Reports, a letter from the Alliance for Automotive Innovation, a letter from the Center for Democracy and Technology, and also a letter from the Intellectual Property Owners Association, which I asked to enter into the record with unanimous consent.
Without objection, so ordered. I'll now recognize myself in closing a little bit here, my round of questioning. You know, we've had a lot of discussion. I want to try to bring a couple of items back. I talked earlier about 2 authentic parts that are not able to be put together without a third-party tool. Of the 5 of you, does anyone defend the authentic parts bought and paid for by one or more individuals from being continued to be used and put back together somehow as a right of the manufacturer to prohibit? Yes. Anyone? Mr. Hartzline, I had a hope that you might.
You were looking at me, so I'm trying to understand. So this is like a re-authentication thing. So like
exactly. If you, as Mr. Roberts said, if you or Mr. Roberts, if I take this phone, which has a dying battery which needs replaced,
yep,
and my other phone which has a cracked screen, and I go in and say, could you make one of them work for me, please? Put the good battery in with the good display, or vice versa. Both of them have a chip interface designed to stop them from being put in. As a matter of fact, even though the battery's authentic, if I simply put it into a different one, it will tell me, and it will give me an error code saying it's not an authentic battery every time. I love Apple. I've consumed a tremendous amount of their products, but that is deliberately designed, even with authentic parts, to prohibit the reuse.
I think there's a lot of business reasons why they do it, including security. And I know it used to be, you know, you put your thumb on the thing to open it up, and so they wanted to make sure that people weren't able to replace it to break into people's phones, and all of our personal information's in the phones. But I understand that Apple in particular, you don't have to go to the Genius Bar anymore, right? They have a repair program. They'll actually send you the parts. They'll sell you the parts. They'll send you the tools. It's the exact same tools that the guys in the Genius
wait a second.
Bar have, right?
The only question before us is whether it's Apple, and I don't want to talk about Apple particularly because each of these companies is different, but if I remove from my BMW, at least during certain models, I remove the radio, unplug it, and then plug it back in simply because I was fiddling around with the dash, I now have to go back to the dealer to reinstall it. Similarly, the transmission example, I've got 2 John Deere tractors. One's got a busted engine, the other's got a busted transmission. Currently, they will prohibit you from moving the transmission from one to the other. From a standpoint of intellectual property, where in God's green earth or the Constitution are any of those designed to be rights that belong to the manufacturer rather than rights that belong to the owners of those 2 John Deere tractors?
So those are a bunch of different situations, and so I think there would be underlying facts that differ with each, right? So we started on the iPhone, and I was going to point out that iPhone will actually give you the tool to synchronize it. In those other situations, I don't know the business justification for it. But if it's not an IP problem, like how is that an IP problem, right? So if that's locked up with the TPM and you have to bypass the TPM, well then that's a violation of 1201. So that's how they can lock.
So what
you
you're
in.
saying is that Congress has created impediments to the right to repair. Mr. Roberts, would you say that is correct? That in fact the right to repair, were Congress never to have done anything since, George and Thomas were our presidents, so to speak, knowing those two presidents, we'd be able to do things we're not able to do because they're now prohibited by acts of Congress.
Yes, and we certainly know going back to the 50s, 60s, 70s, there was a much more, first of all, companies would ship products with service and repair manuals, with detailed schematic diagrams, with the understanding that owners would want to replace and service them. And what I would say is, yes, absolutely. I doubt very much, and I know we had members who were here in 1998 authoring the DMCA. I think if you had said to them in 25 years' time, this law will be used to prevent somebody with a broken dishwasher from getting that service by their local repair shop or for fixing it themselves, this law will prevent them from doing that. I doubt very much they would have said, yeah, that's pretty much what we want.
Well, yeah, I will tell you that I was the chairman of the Consumer Electronics, what is now the Consumer Electronics Association in 1998, and we did predict a lot of these items were going to be expanded beyond the scope of the original. I've got just two closing quick questions. And then the ranking member has a couple questions. Constructive abandonment. Is there anyone that disagrees that when a company takes, for example, its copyright and simply abandons it, that in fact the historic intent, not codified in law, but historic intent is that if you abandon your copyright, such as you no longer make the instruction manuals available, or your firmware updates simply are no longer posted, or your company goes out of business, in fact, even though today, from time to time, there is contest, is there anyone that doubts that that should be a protected right to the consumer to be able to get that now obsolete or unavailable data? Seeing none, I will take that as the first full agreement of the day. The last one is there anyone that doesn't believe in the first use document that if I buy authentic product, that I should be able to use and reuse it, and that any attempt to turn a piece of equipment into a brick simply because it transferred from owner A to owner B is inherently wrong under the many traditions and laws of the United States? I'll take that as agreement number 2, and I'm now told to say the following. I have introduced a bill under discussion, the SMART Act, H.R. 1707, which would help solve the problems of limited access to parts, and my colleague, Dr. Dunn of Florida, has introduced the Repair Act, H.R. 906, which would help solve and issue limited access to basic repair and maintenance and data in your vehicle. Question is, would you commit today to work with us, each of you on the panel, in advancing those bills and making such changes as would make them acceptable to all of you? I see yeses, so I'll take 3 in a row, and I now recognize the ranking member.
Thank you, Mr. Chairman. This question is to both Mr. Benavidez, and Mr. Roberts. The 2014 Memorandum of Understanding between the original equipment manufacturers and the repair associations guaranteed that the OEMs would provide the same service information and tools to independent repair shops as they do their franchise dealers. How has this agreement worked in practice, and do you believe we need federal legislation on the right to repair?
We would hope that it would stand on its own, our agreement with the automakers. We are not against legislation if it adheres to this agreement. We do not right now have any shops clamoring for data. We just don't have it. We get it from the 2014 amendment. we get this data now. We use this data every day. We are able to repair these vehicles with that data.
Thank you. Mr. Roberts?
We urgently need a federal version of the Massachusetts law, the Repair Act. A couple of reasons why. First of all, Mr. Benavides is right. Right now, this is not an urgent issue because most of the cars out there are older vehicles. As we move forward, as telematics systems evolve, as automakers continue their trend of moving more and more information to telematics systems, this is going to become a bigger problem. I'll point out another problem, which is the Massachusetts law is contingent on data transfers of diagnostic and repair information via the OBD or onboard diagnostic 2 port under the dashboard. That's only there because of federal clean air law. Electronic vehicles don't have that port because they don't have emissions. And so in the very near future, as we shift to electronic vehicles, that data access port will no longer be there. It will all be telematics data. And so the utility of the Massachusetts law is going to decline over time going forward. And again, when you start talking about right to repair, you become like this crazy person who talks about right to repair every time it comes up. But one thing I try and stress to people when I talk to them about auto repair is if you live in Michigan or California and you have taken your vehicle to the local independent repair shop, you have only done that because the voters in Massachusetts passed a ballot measure over a decade ago and then updated it in November 2020. That is the very thin thread that our right to use independent auto repair hangs by in this country. That's not the way it's supposed to be. This is something that affects vehicle owners, hundreds of millions of them in all 50 states, and it's a type of thing that the federal government needs to address with federal legislation. It should not hang by this very thin thread.
Thank you. Professor Hartline, are software updates new creations? And thus copyrightable?
Software updates, yeah, they're computer programs, and so Congress said explicitly in 1980, but it was understood before then that computer programs are literary works, and they're protected just like any other copyrighted work.
Thank you, Mr. Professor Perzanowski. Do you disagree?
I don't disagree at all that software updates are protectable subject matter under the Copyright Act. But what I think is important to keep in mind, right, is the Copyright Act and copyright's exclusive rights and all of the exceptions and limitations to copyright's exclusive rights are created by Congress. And so if you think those rights are interfering with other important issues and concerns, then I think Congress clearly has the power to make changes to the copyright law in order to best serve what you ultimately determine to be in the public interest.
Thank you. I yield back.
Thank you, and I'm going to follow up just very briefly on that. Mr. Hartline, you said that it's a right, and we already talked about abandonment, but let's leave abandonment alone for a moment. Copyright is not a right to exclude, as you know. For the most part, copyright, you get a reasonable fee or a license. You don't, if I have a piece of music, I don't inherently have the ability to stop people from performing and the like. So we understand it is different than patent in the sense of the right to exclude is not traditional. But let me ask you an important question. If I give away my software to every single person, I put it online and allow you to update it, I even push it through to try to encourage you. In fact, I make it to where it's a nuisance to use your iPhone if you haven't updated because it's going to give you the red thing. If I do all of that, have I in fact, to a great extent, made my copyright a public domain for purposes of authentic users of the material using it at their own pleasure? For example, that iPhone 8 or 9 or 10, the archived copyright when Apple no longer updates?
So I disagree with your premise respectfully that copyright is a right to exclude, right? We can exclude other people from making copies, from distributing copies, from performing, from displaying. But I understand what you're saying. If you're putting out these software updates and people download them, the person who created those things is not giving up their rights because you have to distinguish between the copy, which the recipient gets, and then the copyright, which the copyright owner
I understand
pays.
you don't nobody gets ownership of the original text or software and the like. But the fact is that if you give free to many, do you give free to all? Mr. Roberts, you were shaking your head perhaps a little differently. I would like to close this off by having people answer that basic question of, if you're a company, and we'll leave company names aside, but you make VoIP phones, and you push through not only the original firmware, but all the updates for months or years, and then a hypothetical, the transfer of that product, they simply say, well, you no longer own that. Is that really consistent with existing law, recognizing that we have the right to change law, but even under existing law?
I think it's unclear, and I'm not a lawyer, so I don't want to weigh in on that. All I would say is that the cost to society of manufacturers being able to reach beyond the point of sale and exert that type of control on, sale and reuse of their products is very high for consumers, and from a cybersecurity standpoint, presents many problems in terms of maintaining, again, a secure ecosystem of deployed devices that are internet connected.
Okay, and my last closing statement was my opening statement. We all understand that there is what we call a standard patent, one which you do not have the right to exclude, but rather because it has been put into use as a standard essential patent, it therefore is entitled to reasonable royalties, but not to exclusion. Who would like to make the case that an equally standard essential copyright should not and does not effectively exist when it becomes essential to the continued operation of a product, or even when that copyright becomes part of a standard? Who would like to argue against it? Yes.
So I think this idea of a standard essential copyright is getting at something really important, right? Access to firmware and other code is really essential to the functioning and repair of lots of devices. I think there are some important differences between the standard essential patent context and kind of what we're talking about here, in that in the standard essential patent context, we're relying on standard setting bodies to identify technologies and to require companies to license their patents under fair, reasonable, and non-discriminatory terms. We don't quite have that infrastructure in place in the copyright context, but what we do have are compulsory licenses that exist within the Copyright Act already, one of which you were alluding to earlier, the mechanical license for musical works. We also have compulsory licenses for retransmissions of satellite and broadcast content that essentially say the copyright owner is entitled to compensation of some form, but they're not entitled to prevent people from using or accessing that underlying work. And I think that could be a useful framework here for getting owners of devices access to the firmware that they need.
Well, and that is to be continued, as you can imagine. This concludes today's hearing, and I want to thank our witnesses for not only being here, but staying into overtime. Without objections, all members will have 5 legislative days to submit additional written questions for the witnesses and additional materials for the record. And with that, we stand adjourned. Thank you.